Best for battery in those cases, to where the homeowner, for example, one I can think of, an intoxicated man, he's kind of a area drunk, if that makes sense. He falls asleep in this guy's shed. The guy's a trained fighter and just beats the dog out of this guy. No, that's battery all day long. And does that sound reasonable? Did he need to go to that extent? He could have called us. The guy could barely move, but he just pounded him. Now, I don't know if it was a Fort Wayne case. There's a lady, she's actually talking to a 911 dispatcher. She's an older lady, older lady, we'll say it like that. I couldn't find the words. Anyway, and you can hear her talking to the dispatcher, and this gentleman had entered her home. It's a burglar. He's going to rob her. And you can hear her on the 911. I thought it was you guys, maybe it wasn't. And she's talking, you take one more step. And she's got a gun. You take one more step. I'm telling you. And sure enough, you hear, bang! I told that. She shot him right in the gut. Was that Alan County?
I don't think so.
Shot him right in the gut. And here again, reasonable. This guy was a full-grown man. I can't envision him from what I've heard, 6 foot, 220, and here she is, all of 90 pounds. Does that make sense? And I think even at the law enforcement level, that's probably, something that we're going to sit down and talk to the prosecutor, not just file a case against somebody to get their advice on it. Anyway, I just wanted to throw that out there. I kind of heard, when I was listening to law, and you think about protecting your land, you'll hear that. Anybody steps on my line, that's it, that's a butt kicking. Be a little careful of that.
Well, go back to your red book, the second edition, where I think it was Vernon Lorenz, you quoted it there?
Yeah, I wish I had that. Nobody remembers anything I wrote, and I swear to God, everybody remembers that, though. It's Vernon in my office. If you need a jury trial attorney, he's a genius. He doesn't care about law, but he loves juries, and so he's proofreading the second book, and I'll try to find him and read him to you, but he's like, you got it all wrong. Don't worry about this. Here's what you need to know. If you're I forget what he said, if you pull the trigger and you say, oops, you're probably going to prison. It's basically those kind of like 10 simple steps.
But the one that I'm thinking I want to get to is if a prosecutor reviews your case and decides to press charges, your claim of self-defense is likely garbage or something, words to that effect. And that's where I wanted to get into with Bob playing prosecutor hat and you putting on defense attorney hat. That we have somebody, it doesn't have a great disparity of force issue that's involved there. It's a deadly force situation, claim self-defense. It doesn't have to be the Trayvon George Zimmerman case. But you press charges, you end up being the defense attorney, and I make a generic case out of it. So how are you going to come at that person? And how would you defend? I mean, what are the tricks of your trade, and what could you expect to get hammered? Because you're going to try to crucify the person.
Sure.
Basically it.
Sure.
And you're going to try to get him off the cross. Is basically what it boils down to. So maybe I can throw that out for some panel discussion or something like that before lunch.
Well, I'm going to come at it as a prosecutor to do everything I can to make what you did appear unreasonable. Okay? That you didn't turn around and run. That you didn't try to get away. That you stayed there. That perhaps you didn't call the police and you had access. I'm going to ask, well, in this day and age, you had a cell phone. You could have called somebody. Now, it depends, again, on how close they were and the immediate threat. But I'm going to do everything I can to do that, to create the distance between you and the other person, in this case, the victim. I'm going to show that the victim did not carry, did not have a deadly weapon, and that the fists that maybe were balled at his side weren't threatening enough to you. I'm going to do everything I can to show that your response in using deadly force was not reasonable, that you had other alternatives, you had other ways out to do that. Okay. If I may, I'll give you a real, and Brian then can speak to this, a scenario that did happen in Fort Wayne. A young man who has a permit, carried his weapon, small of his back, it was concealed. He went to a bar, just saying, no good happens after midnight at a bar. Right? They went to a bar, and he got into a little confrontation with some other people. He and his friends and some other people. They left. There was a little confrontation in the parking lot. Both parties left. Both parties end up at the same location. The young man carrying the firearm is about 5'7", maybe 170. The other gentleman, who was not carrying a firearm, about 6'4", good 340, big man. He gets out of the car and starts approaching the young man with the gun. Still does not know the young man with the gun has a gun. And he starts talking to him. Look, I'm going to kick your ass. You don't get away with that. And starts approaching him. The young man with the gun says, come any closer, I will shoot you. Still does not show any weapon. The big man keeps coming. He says, look, come any closer, I'll shoot you. Big man says, you don't have the cojones to do that. You don't. Little man says, don't come any further. You don't have the cap. He goes down. There's a second shot. As a prosecutor, you had the ability to get away from him. You could run. But as a prosecutor, here's my big point. Why'd you shoot him twice? If he's going down with one, why does the second shot go off? If the prosecutor charged you, you're going to jail. You shot him twice.
And Terry Mason. I mean,
The no good comes from alcohol and guns. I actually, where I live, my whole world's 3 blocks. So my office and where I live are right together. I live right next door to a place. I don't cook, so I eat out every meal pretty much, and I walk over there. They serve alcohol, and 2 high-level IMPD people eat there as well. And if they're having a drink or I am, we don't carry guns. That takes that out of the equation, because if there's alcohol in your system, even the most justified use of force is going to get really spun out of control. The other thing that I want to say as a defense, from the defense side before I respond to that scenario is, don't forget in the statutes for deadly force, there's still the word reasonable. You can stand your ground if, and it goes on to say you can defend your occupied motor vehicle, and goes on to say if it's reasonable. So be careful about that. But what you also need to think about is that's the role of law enforcement. They're the ones that are supposed to handle those scenarios. That's the reason they have some immunity and they have body armor. If you have the ability to get away from your situation reasonably safely, you should always do it, because no matter what happens, if you use deadly force, to a statistical certainty, you're still facing a $50,000 legal battle when the family of little Jimmy says, oh, he was a good boy. Now, his rap sheet's 30 pages long, and this went on with the police officer where I knew. He had the mom's up in the family. The police officer was unreasonable in shooting him in the car. Well, he believed he was going after a gun, and he had a long rap sheet. And then there's a civil suit. Police officers have immunity acting under color of law, and you don't. So think about that. If there's a reasonable way to retreat, you should. On the issue of this particular kid, there's a lot of variables. Did they do a blood draw? Do they actually know he had alcohol in the system at that point in time? The probabilities of them winding up at the same place at the same time from a defense standpoint can get spun. This guy was following him is one way that could get spun. I will tell you though, probably the little guy made a statement, and once you make the statement, you're welded to it, and the response is when you later say, well, he was following me, or he was running toward me or moving fast. If you didn't say that before, the issue is, why not? When you haven't said anything, all the subtle facts can get teased out that were going through your mind, but then why didn't you say it? It's, oh, well, you got buyer's remorse now. It's an unjustified use of force. The second shot, that also, if you haven't said why you shot him second, well, because he's a big son of a bitch, I want to make sure he went down. That's what you read from my side in these transcripts. I mean, really, as somebody that's been trained, you're going to shoot probably 3 times anyway. If you've done gun sight or any of the training, again, that's a standard response. But are they wearing body armor? Do you know that? So you're going to shoot. I mean, if you have the ability, the training is twice in the chest and once in the head, and that presupposes you can actually hit your target. And I'm sure all of you can. But there's a way to explain that second shot if you haven't already made that statement. So there's ways to unpack this. The prosecution's job is to make it black and white for a jury. The defense job, on the standard of beyond a reasonable doubt, is to make it gray enough so they're sitting back there in the jury room scratching their head, and they either acquit him, saying it's not a high enough probability to be beyond a reasonable doubt, or you get a hung jury and then you go back and potentially try it again. But question?
Yes. Could you reiterate what you said about making a statement? Are you saying that the little guy says, if you come any closer, I'm going to shoot you, or I have a gun? Would you expand on that? About
okay, I wouldn't make that statement. The only time I'm going to use deadly force, I'm not going to be stating that to a statistical certainty. Every situation's different. If there's 10 guys closing in on me, I might change it in the heat of the moment and think, I only got 6 rounds in the revolver. I'm going to make that statement. But typically, you shouldn't have, when you've made the choice, if you've got enough time to make that statement, you've got enough time to fled or retreated. And I would think that probably that kind of statement isn't something that's going to come up in a typical deadly force situation. I wouldn't have made that statement.
You're saying don't make that kind of statement
to someone unless if you're to the point that you're ready to shoot someone. You should either be running if you have the time to think about it, or the decision should have been made and it should be unequivocal in what your choice is. That's the answer. Every one of these answers has exceptions, but that's the rule that's right 99% of the time. Question?
Yeah, it seems to me like for myself, and maybe for a lot of people in here, you have to look at yourself and say, am I able to make a decision in the heat of the moment that viewed by others later would be judged to be reasonable?
That's exactly it.
That's a big expectation when you're faced with a situation.
And I'll give you an example. And I teach a lot of lawyers, and so if you look at the codes that we're mentioning here, they're great, but you look at them and your eyes glaze over, trying to figure out what they mean. Deadly force, conceptually, if you haven't heard this, I'll throw it out, can really be boiled down to 3 categories. You can use deadly force, again, it's got to be reasonable, to defend your home, occupied motor vehicle, or dwelling. You can use deadly force to terminate a forcible felony, or you can use deadly force if you're in reasonable objective fear of serious bodily injury or death. And serious bodily injury to the lady that got picked on up here may well be me punching her, showing no gun, may be enough for a prosecutor not to charge her or a jury to acquit her. If the tables are turned, that may not be considered to be serious bodily injury or death. But the point you make, which is a really good one, do you really think and understand how that plays out? If you're in a bank and the bank's being robbed, you may well be able to use deadly force to stop and terminate a forcible felony. If you see Fred down there, who just got out of prison for check forgery, and he's writing a bad check, and you shoot him dead, I mean, they're both felonies. They both may have the same class sentencing range, but you got to be thinking. It's a thinking game. If you're here and there, I know police officers think about it. If you're in the gas station, the convenience store at 3 o'clock in the morning, then what are you going to do if someone does come in and run? I'm going to hide, but you need to be thinking about that. I had a guy the other day that came in, and he's risking losing his license, and he said, I'm like, are you sure you want to fight this? Yeah, I want to fight it. He's like, my friend lives in a bad area, and I'm always going there like at 3 or 4 o'clock in the morning to see him when I get off work, and I might need a gun. I'm like, if you're thinking that ahead of time and you're still going there, you have no business with a gun. You're violating the number one rule, which is don't be somewhere that you don't have to be when you think there's a risk going there. So analytically, you got to be able to think about where can you use deadly force, and those are the 3 categories: home, curtilage, occupied motor vehicle 1, to stop serious bodily injury or death, and or the forcible felony category. Those are the 3 categories. You'll find other things in the code, like to stop a hijacking. A hijacking is a forcible felony. That's how you analytically make this make sense to yourself.
I had a question about something you mentioned earlier. You said that a police officer is protected under color of law from lawsuit. Let's say that you are involved in a shooting. The prosecutor gets a case. He determines that you've used reasonable force and you're justified in that shooting. Now, under Indiana law, you're obviously aware of it. It says no person in the state shall be placed in legal jeopardy of any kind for protecting the person or third person by reasonable means necessary. Does that mean that you cannot be sued civilly, or can you still be sued civilly if the prosecutor determines that you used reasonable force?
Two components to the answer. This is a really important question, and it applies across the board in lawsuits, you'll see. First, that statute is not a strong statute. The Court of Appeals has interpreted that statute to say you're not held in jeopardy because you have the right to the judicial system, which means the prosecutor can prosecute you and you get acquitted if you're not guilty. So it doesn't keep anyone from prosecuting you civilly or criminally. In the event you make the argument that you were acquitted or the prosecutor didn't prosecute you, that's because they don't think they can make their case to the high enough burden. Civilly, if you have anything to get, you're going to get sued civilly, and it's more likely, and the O.J. Simpson case is a perfect example. He murders Nicole. He didn't murder her, but assuming he murdered her for purposes of this, he gets acquitted because the prosecution didn't make it as black and white, and the defense confused it to death, and you get the random glove in there. But civilly, he lost that civil lawsuit because it's a lot lower burden of proof. So if you're acquitted or not charged, or a grand jury doesn't indict you criminally, that doesn't mean you're not going to get sued. Now, I was involved a few years ago. You might remember there was a huge IMPD shootout where Kenneth Laird was killed. The guy, Jake Laird was killed. Kenneth Anderson was a guy that was a few screws loose. He started shooting up everybody and everything and shot several IMPD officers. Coe was one of them. There was no insurance. There was no possible way of recovery to sue. So in that particular case, there wasn't a civil lawsuit. But if you have any insurance or any probability of having any money, or your friend's gun is the one that you're using when you had the deadly force encounter, they're going to sue your friend and say you knew he was a wacko and you negligently entrusted him with your gun. So recognize that the civil burden and that statute doesn't do much for you. And civilly, you're going to get sued.
That was only if prosecutor declined charges. If it goes to trial and you're found not guilty, does that grant you? No. Okay, so
no, totally different, because the crime is that you're being charged for and found not guilty is a crime against the individual, but really it's a harm against the state. That doesn't change all the other people who are going to indicate they were harmed. The person that was shot, the wife who's arguing for loss of consortium and the medical bills and the cost of having to bring someone else in to pay for the food and groceries. So that's how that plays out.
The gray area that I have a question with, and again, my wife has asked me this as well, I really don't have an answer for her, with regards to home protection. You hear a noise at night and somebody is downstairs, or you surprise somebody that's in your home. The question I have is that obviously I don't want to use deadly force unless I'm in fear of my life or I absolutely have to. But let's say you surprise somebody, and you gave the instance about the woman of don't take another step, or I've got a gun and I'm going to use it. Obviously, there's that dividing line of you're standing there with a shotgun, let's say, and you've got it pointed at this person that's rummaging through something, or they're in your home. Your family's upstairs, or whatever. How do you know, where is that, how do you draw that line to determine, hey, I've got a gun on you, to not use it or to use it based on his actions, from the point of calling police at the same time and holding him at gunpoint, waiting till the police arrive, or if the person makes a move towards you or moves in general, you don't know which direction he's going, before the police arrive, that you have to use that weapon to stop him. That's my question of reasonable force. Does that make sense?
Yeah, I think you raised two different questions. If you get up to go to the bathroom in the middle of the night and you startle an intruder, the probability that you're going to have a gun on you is pretty small. Now, if you're paranoid like I am and you sleep in an ankle, my fear is I'll wake downtown, I'll get somebody on top of me. I sleep with I rotate ankles, a Galco ankle holster with an airway. I wouldn't get surprised, but those are different questions. The probability is you're going to be, the bad guy is going to have the up on you if he startles you. If you think they're in your house, you ought to have your plan for where you're going to be and call the police and wait on them. And then you get into a whole different situation of making sure you stay on the line or otherwise with the 911 operator so you're not the person when the police officer's coming in that's got the gun pointing at him, because that's going to have a pretty probably not happy outcome.
Because there are times when my wife will wake me up and hear something, and we don't know what it is, and we're on 2 floors. And the way our home is positioned, I can actually look downstairs without being downstairs on what's happening and see the greater majority of our downstairs house. I don't go hunting, as Bob had made a suggestion. Don't go hunting for this person and call the police first. But with that said, I also don't leave the room without a pistol on me, or a shotgun, or both, whatever. And so you never know when I may interrupt this person trying to see what I can see. And if I make visual contact with somebody, I'm at least going to draw on them enough to hold them right there, because I don't want them leaving my house and going to the next person's house while my wife is on the phone or whatever the case may be. I don't want him leaving or coming back because he's pissed that he didn't get a chance to do what he wanted to do and he comes back later, because then we have the fear of, is this moron going to come back in a week or 2 weeks, or does that make sense?
Yeah, I think it's going to come down to if you're the pit of your gut, if you really think somebody's in your house, you should call the police and stay where you're at and have a secure place to stay at. If it's going up and walking around your house, you're probably not going to have a gun. Those facts, though, can cut either way. A good criminal defense attorney would take them one way, and a good prosecutor would rip your head off. Well, how in the hell is it you don't think you invited this by walking down, you wouldn't engage him, why didn't you call the police? And he's standing right by the door, why did you shoot him? He was going to run out the door anyway. On the flip side of it, you can make the argument that, depending on what you've said, that you really did think there was an intruder and you weren't sure where they were in your house and your kids are in a different place. It's all how the facts are unpacked. I will say this, for the most part, when you get out of Marion County, if you get into the donut counties and you get further out in the country, your home is sacrosanct, and what happens in it is probably going to be given a lot of deference by prosecutors, but those aren't the typical situations where you have a deadly force encounter that's going to happen, statistically speaking.
What if a guy just turns around and starts to leave? Says, hey, I'm out of here.
Let him go. Let him go, call the police, and move on.
Which is kind of odd to me, but the aspects of the self-defense thing, as I understand it, you were in a place you had a right to be. You did not initiate or engage willingly in the act of violence, and 3, you're in reasonable fear of serious bodily injury.
Well, that can get to the jury. Yes. And for the self-defense, you have to be in a place that you have a legal right to be. You can't be the aggressor of the situation. And you have to then use the reasonable force. You know, as former chief, so-called chief, as chief just said to me, Lena, but a lot of times that's for the jury to decide. And that's the unfortunate thing. You make that decision on the cusp of the moment, and then you have to live with it. And I think that's partly what Brian is saying, is that's what you really have to think about. You have to be aware that what you're doing and how you're acting is going to have a ramification for you somehow, some way. whether you end up having to bond out and wait trial in a criminal case, whether you get sued by the home invader because you injured him or her, all of those things are going to have, or your name's going to be plastered in front of the newspaper, and you're going to lose your job for whatever reason, and your family's going to have this stigma attached. It's going to have impacts and ripples far beyond what occurs that night. So if you have you have to be in a place you have a right to be, your home. The person is in your home. As Brian said, why be the aggressor though? Why confront the person? If you know they're there, you stand back, you wait, you call the police. If they come to you, that's different. Don't go to them to force it. Now, I'll be the first to tell you, if someone comes in my home, I'm going to be PO'd, man. All right? And the real key here is you've got to take a step back for that period of time and think before you act. I may be pissed. That's why I'm calling the chief. They can come out, they're trained, and they're going to know how to handle it. If the guy wants to leave my house, he can leave. I'm not going to. If you tell the guy he's got to stay in your home because you called the police and things escalate, as a prosecutor, I'm going to probably look at charging you with a crime because you kept him there and it escalated. Now you become the person who's created the situation. So personally, as a prosecutor hat on, I'd say, go. Vamoose, bye-bye. I'll get the best description I can and give it to the police.
I got a one-eyed boxer. He does that job for me.
Just one another feel on it. I see, and you guys may know this, but I got this recently. I thought it was a good idea for people worried about an intruder coming into their home. If you're in a situation where you have like your keyless entry, you keep your car keys in there by your bed, press that horn button, and your car horn starts honking, the lights are flashing. You know, sometimes that's enough right there to get the threat away. You know, just, I thought that was a pretty good idea.
Yeah, we have an 85-pound red Doberman that goes pretty well.
Then there was always a case where the guy that was walking down the sidewalk and a fella come out of the alley with a knife, says, "I want your wallet." The guy says, "I ain't got a wallet. All I got is this handgun."
I've always wanted to kiss in the old Oh, we got a lot of. Go ahead.
I'm going to bring this up. About a year and a half ago, our neighbor across the street, he's a registered sex offender.
Oh, great.
And I got a 12-year-old and a 16-year-old. So I think about this a lot.
Daughters?
Mm-hmm. Since then, I put them in Taekwondo. At times that me and the wife would want to go out, well, we wouldn't because, you know, was really scared about leaving them there by themselves. Grandma was right down the road. And so we started feeling like we were just trapping ourselves. And so we just started, you know, okay, girls, we got some Louisville bat sluggers, you know, the little ones. Got a big one. I just told them, it's like, you know what you learned in Taekwondo? Someone comes to that door. You just start swinging, and you call the police. My thing is, if they beat this guy up, and he runs out the door, if he calls the police saying I was just attacked, here you got a 16-year-old and a 12-year-old who just did it. What could happen?
Let me put my old prosecutor hat back on. I'm going to give you girls a medal. You know, the situation there is, again, look at what was reasonable. He comes in, he's not invited in. Most people are going to believe the 12 and 16-year-old that they didn't invite him in. And so he comes in, and he's not wanted. Your girls have a right to defend their place and themselves. Now you get to the point, as someone said here earlier, I think it was Chief, you know, if they hit him, my son does Taekwondo too. So if they knock him down and he's out, don't pull the Louisville out and start finishing him. All right? You got to know when to say stop, even though they're 12 and 16. But as long as they are still concerned for their well-being, from a prosecutor's perspective, I'm going to look at that a heck of a lot different than I am if it were you. I might have more questions for you if you did it to him than I am for your 12 and 16-year-old. Now, what could happen if you get a prosecutor that says they went overboard, they could find themselves in juvenile court answering to a charge of battery or something
even
like
though he's registered.
The fact that he's a registered sex offender makes no difference to me as a prosecutor. Okay? Did he enter your home uninvited, and did they have a reasonable, did they act reasonably? Did your daughters act reasonably in that situation? Now, the defense attorney is going to spin it. Look, if your girls were charged, going to say, look, they knew what his background was. That doesn't necessarily get in front of a jury. All right? So there's a whole realm of law that deals with what you know about the person coming at you and what you don't know and how you know it. If you've been told Bob Gevers is a violent SOB and makes a habit of going around kicking someone's butt, and you know that about me, how does that figure in? Can it figure in? I won't get into all that because, again, there's all sorts of case law. But if you have seen me on occasions beat the crap out of people and know that I am a violent person, and now I'm coming at you, and you have that knowledge of me, that's going to make a difference on how you react as well. Right? So there are various things that go in there, but at this point, making that decision as a prosecutor, I'm going to look at it and say, I don't care if he's a registered sex offender or a convicted burglar or the minister. He came in, they did what they had to do to protect themselves.
I'm going to add to that real quick. That question came to my office quite a bit as chief. You know, how do I have my children defend themselves? Some elderly people would ask me that, and I always got concerned when they would say, you know, like a bat or even firearm for that sake. You know, shooting a target's a whole different scenario than sending something downrange at somebody. Trust me.
Right.
So your fine motory skills start to lose. I would always suggest pepper. I'd go with chemical spray. I had lots of people. There's products on the market, usually off of a chemical spray. I say usually. 99.9% of the time, you're not going to have any permanent damage. You're not going to have anything that they're going to recover eventually. It gives time for escape. That's the thing that I like. I had a lady that came in. She was in her late 70s. She had been burglarized. She was really scared. Fortunate enough, someone had come home and scared them off, and I think we found her some grizzly spray with like about a 75-foot cone. It's a true story. You know, I found it in the catalog, and she sets it next to her chair, and they came in through the front. All she got to do is pull the pin, hit the button, and it's all done. I mean, it'll do the whole hallway. So
it's going to do her too.
Well, you know, it goes out. She just got to kind of get this way. But anyway, chemical's not a bad idea. Even if it's taken away from you, if a firearm's taken away from you, that's a death type issue. If chemical spray, you still have a chance to flee. And you know, if you're running 20 feet in front of them, they can't necessarily get you with the chemical spray. Does that make sense? Whereas with the firearm, they could. So that's just my suggestion. I'm big on chemical.
I'm big on that because again, it's not permanent. And I've actually I was driven by Lily downtown Indianapolis one time because I get some really crazy cases, some pretty serious death threats. I actually had pepper spray for a demo bottle somebody had given me to give to somebody else, and my briefcase fell over. It actually spraying out through the air conditioning. I thought there was a chemical spill. I'm out in the middle of the road. Pepper spray will work. The trick is, if you're going to get it, don't get the little cute one that's on a key ring. Get a police size. It's got enough range and enough charge, and recognize they have a shelf life and change them out.
Grizzly, I got hit by that. That'll knock your socks off.
Yeah,
I have a wasp spray near the front door. It's used with wasps and hornets.
I'm not so sure, though, what damage that could cause to a person. That's where I'd be concerned. Does wasp spray, would that cause some permanent vision? That's why I might switch to it.
Let's be a good place to break. We're good for here. And what I'd like to do is let our panel have the first crack at it, because I know they're going to be around. Are you ready?
I just want to say something. Fine, folks. Now, if you don't like the barbecue, I intended no harm, so don't shoot the cook.